Hi friends, welcome to the channel. This is your Govindraj. Thank you very much for watching my videos and also sharing it in your network. More particularly, thank you for being the membership only channel member. Today, we are going to take an important topic under Maternity Benefit Act 1961 and also ESI Act 1948 with related to the period of maternity benefit in case of third child. That means if you look at section 5 of Maternity Benefit Act, so normally under normal circumstances the maternity benefit period is 26 weeks. However, under subsection 3 of section 5 there is a specific restriction that in case any woman employee having two or more surviving children, in such case she is going to get 12 weeks of maternity benefit, so not more than that. So that is a restriction available in the statute. Now, is there any possibility of 26 weeks maternity benefit even in case of third child where woman has got two or more surviving children? That is the topic of question for today for us to debate and conclude certain points and certain questions. Now, as I told you, if you look at the provisions of subsection 3 of section 5, first proviso very clearly talks about if any woman employee having two or more than two surviving children shall be eligible for 12 weeks, of which not more than 6 weeks shall precede the date of her delivery. So this is what is the available restriction in case of women having two or more surviving children. This specific provision has been brought into the Maternity Benefit Act 1961 by way of 2017 amendment, and therefore this basically the amendment comes with the objective of ensuring the government policy of family welfare and population control. Probably the government would have put this restriction in order to take care of the population control and also support the family welfare of the Indian citizens. But however, if you look at the entire framework and the structure of the act has not specified any ceiling or cap on the number of children to claim maternity benefit. So that means it is not putting any restriction for the claims for maternity benefit even if the woman has got more than two or three or something, but only if woman employee has got two or more surviving children, in that case the maternity benefit is restricted to 12 weeks. But the act is not denying maternity benefit irrespective of number of deliveries and number of children. So that is the interesting factor which we have to keep it in mind. Considering this provision, I have framed these questions. These are the doubts which may come up in anybody's mind. The first one is whether the benefit is linked to number of deliveries. How about a case where the twins are born in the first delivery? So that means the act is talking about two or surviving more children for 12 weeks, and suppose if in the first delivery itself the woman gets two twins or the twins are born, in that case for the succeeding delivery or one more delivery in the next, is she going to get 26 weeks or 12 weeks? Now the third question is, how about an employee who has two surviving children but joins a new employment and claim 26 weeks maternity benefit for third child? In this case, what is happening here is she has claimed already two maternity claims in the previous employment, and there are two surviving children, and she goes to another new employer, she becomes eligible for maternity benefit, and then she claims the maternity benefit. In such case, whether she is going to get 26 weeks or 12 weeks. So that is the third question. The fourth question is, how about for the children in the second marriage, also when the previous two surviving children are not in lawful custody of the woman? Is there any relationship with the marriage? If suppose any woman employee or woman employee gets into two marriages, and in the previous marriage she already has got two surviving kids, but the lawful custody is not there with the woman, in such cases is she going to get 12 weeks or 26 weeks? The fifth case what I am going to take is, how about a case of remarriage where a spouse or the husband has already two surviving children in his custody? So when the woman and the husband or the man gets married, whereas the husband from his previous marriage already has got two surviving children. When they get married again, so the new woman, then his children are going to be in the family as, and they are going to treat as their own sons or the daughters. In such case, if the woman employee again she becomes a pregnant, in that case, is she going to get 26 weeks or 12 weeks, even if it is her first delivery? What is the case? That is the fifth question. And the last question what we are going to address is, how about an employee with two surviving children not having claimed the maternity benefit in the past for two children? Suppose any employee joins a employment, she already has got two surviving kids and she has not claimed any maternity benefit with any employer. In such cases, she, when she joins the employment, if she becomes pregnant again, and for that specific case, is she going to get 26 weeks or 12 weeks? That is what is the subject for our debate today, and we will try to conclude based on the provisions of the act. We will also get into the provisions, similar provisions of ESI Act 1948, and we will also see the case laws which are available on these topics. So let us proceed, friends. Now, if you look at the first question, whether benefit is linked to number of deliveries. Now, the answer for this, if you look at the proviso to section subsection 3 of 5, it describes the cases of having two or more surviving children, and hence it is not linked to number of deliveries. So this proviso is only restricting the claim for having two or more children, and it is only lesser maternity benefit is provided. And therefore, if a woman employee does not have two or more surviving children, irrespective of her past deliveries and claims, she will succeed to maternity benefit of 26 weeks. Moreover, if the act does not put a restriction on number of claims. So what we have to understand is, importantly, whether she has got two or more surviving children or not. Even if in the past, if there are more than two deliveries, but there are no surviving children of two or more, in such case, she is going to succeed to get 26 weeks of maternity benefit under the statute. And also, as I have told you, the act does not put a restriction on number of claims. It is only talking the surviving children, two or more, at the time of claim. If they are existing, then she will be eligible for lesser maternity benefit and not the 26 weeks. So therefore, as long as she does not have two or more surviving children, she is going to get 26 weeks. In so many cases, what happens is, even the delivery may fail and the kids who are born may die also. In such a cases, the delivery is not important, or the number of claims is not important. Important is the surviving of two or more children. So therefore, this question is now answered. Now the next question, how about a case where the twins are born in the first delivery? See, if you look at the judicial trend, in one of the case, it is also held that, if you look at the government rules, they provide for additional maternity claim when the twins are born in the first delivery. But however, in case of Maternity Benefit Act 1961, the criteria is two or more surviving children. It leads to 12 weeks maternity benefit, and hence employee may not succeed to get 26 week full maternity benefit for the second delivery. So the importantly, what is the factor here is two or more surviving children. The government rules may provide for the government employees, but if you look at the provisions of Maternity Benefit Act 1961, it is only talking about two or more surviving children. The moment the woman gets in the first delivery, if she gets twins, then it becomes two or more surviving children. So therefore, for the succeeding delivery or the succeeding claim, she will not succeed to get 26 weeks. She will only succeed to get the 12 weeks of maternity benefit. Now the next question what I am going to talk about is, how about an employee who has two surviving children but joins a new employment and claim 26 weeks maternity benefit for third child with the new employer? So the answer, you already know that the claim as per the act is not specific to any employer, rather the benefit which is available to woman employee. So the act talks about only the benefit which is available to woman employee, and it is not very specific to employer. So moreover, the lesser benefit under subsection 3 of section 5 is with the interest of family welfare and population control policy of the government. So therefore it has got an objective. So the very important thing is whether she has got two or more surviving children. It is not that she joins the new employment, she already has got two surviving children. So that is not the case. When she is joining the new employer, the case is what the subsection 3 of 5 section 5 is prescribing, whether she has got two or more surviving children. So therefore, even in such cases, the female employee will not succeed to 26 weeks of maternity benefit. She will only succeed to 12 weeks of maternity benefit. So let us see the next question. How about for the children in the second marriage, also when the previous two surviving children are not in lawful custody of the woman or not residing with her? So this is also a case may be set up. In one of the case related to the government employee, the apex court, while hearing this case, similar to what I have explained, held affirmatively in this case, and also held that two surviving children must mean children in lawful custody of the mother. So if the children in the past marriage or in the first marriage are not in the lawful custody, then she will become eligible for full benefit under the government rules. So therefore, due to second marriage or for any reason, if she does not have the lawful custody of her children or they do not reside with her, she will succeed to full maternity benefit as per the rules. So this is basically based on the government fundamental rules, and this was so held in the case of K. Uma Devi versus Government of Tamil Nadu and others. So I have given the citation here, you can go and read. Now let's take the similar to another case is, how about a case of free marriage where a spouse, husband, has already having two surviving children in his custody? So in this case, what has happened is his husband whom she got married, he already has got two or more surviving children from the past marriage, and they are treating them as their own children, and when it is recorded in the service books, so then it belongs to both of them. In this case, the court held that the fact that the appellant spouse had two biological children from his first marriage would not impinge upon the entitlement of the appellant to avail maternity leave for her sole biological child. Therefore, the employee will succeed to maternity benefit, full maternity benefit. So this is also belongs to the government employee case. Now, both these two cases belongs to government employees, but however, going by the interpretation, liberal construction of welfare statute, the cases under Maternity Benefit Act 1961 may succeed to get full maternity benefit of 26 weeks. But interestingly, what is happening in the Maternity Benefit Act is, this act does not restrict the maternity benefit to third child. Therefore, it is possible to argue in the reverse directions. In government rules, what is happening, there is only maternity benefit is available for two children. In such a case, denying maternity benefit for the government employee for the third child or in these cases is not appropriate. So therefore, the courts have held. But in the case of Maternity Benefit Act, the act is not denying the maternity benefit. Even for the third, fourth, fifth child, the maternity benefit is available at a lesser rate. But however, in the case of sole biological child, it is possible for the employee to claim the full maternity benefit for her biological child. So that is possible. That argument may hold good in the court of law. Now let me take the last question probably, which is in this episode. How about an employee with two surviving children not having claimed the maternity benefit in the past for two children? So she has not claimed the maternity benefit in the past for two children. Now she comes up with employment, and then she claims the maternity benefit in this case. Now this is also related to the case of the government employee where the rules provided maternity benefit only for two surviving children, and she succeeds to get the maternity benefit in this case because she has not claimed in the past, and it is so held in the case of Madras High Court in the case of C. Kohila versus the additional chief secretary. I have given you the details of this case. You can go and read. Now, in the case of Maternity Benefit Act, so the case is related to the government employees, but let us look into the aspect of Maternity Benefit Act. Now, the Maternity Benefit Act 1961 per se does not specify any such stipulation. It specifies the restriction or the lesser maternity benefit for the cases of two or more surviving children, and this lesser benefit under subsection 5 of 5 is with the interest of family welfare and population control policy of the government. And moreover, as I have told you, the act is not totally denying the maternity benefit based on number of children or number of delivery, or even having two or more surviving children. The third child, when she gets into delivery, she is going to get the minimum 12 weeks of maternity benefit. So therefore, employee will not succeed to get 26 weeks full maternity benefit in case of having two surviving children and not having claimed the maternity benefit in the past. So that is also possible. Now let's look into what is the situation in the case of ESI. Now if you look at the ESI provisions, section 50 of ESI Act 1948 and rule 56 of ESI Central Rules talks about this maternity benefit. So in this case, what is happening here? The woman employee will become eligible for maternity benefit if the contribution for 70 days is received in the preceding two consecutive contribution periods. So these 70 days can be preceding one contribution period or two consecutive periods. Totally, the requirement is in need of 70 days contribution. If that is done, 26 weeks of maternity benefit is provided up to two surviving children, and in case of a woman having two or more surviving children, the benefit is restricted to 12 weeks. So therefore, the provisions under ESI Act are similar to Maternity Benefit Act 1961 in case of maternity benefit. So therefore, the cases and the probability of conclusion what we have already seen in different cases remain same for ESI cases as well. So friends, thank you very much for watching this video, and I am sure this this information has benefited you and actually triggered your mind to get into these kind of doubts, and this information definitely will help you for understanding of more and more to have more and more clarity on this. Stay tuned with this channel. I'm going to come back with more and more new videos in the future, friends. Until then, see you soon, friends.